Hi, my name is Natalia Willett and I'm a real estate attorney here in the state of Florida, and today I wanted to talk to you about force majeure and the clause that you see often in the real estate contract. Sometimes you also see it in lease agreements. Every once in a while you see it in mortgage clauses. And force majeure is a big thing now that we're having the COVID epidemic, the pandemic. People are not sure whether they have the right to cancel their contract under the circumstances that are taking place. So I wanted to speak to you a little bit about force majeure. So in the standard Florida Bar real estate contract, force majeure is clause G. And G says in essence that for certain events, which include acts of God, because it doesn't specify epidemics or health pandemics or things of the sort, so it would be considered under an act of God, circumstances which were unforeseen to both of the parties, circumstances which are considered to make the contract impossible to perform, or circumstances which frustrate the entire purpose of the contract, may be used to provide legal justification for non-performance of the contract, which just means a justification contractually to cancel the contract and return the earnest money deposit to your buyer. Or in the event of a lease agreement, a justification for terminating the lease early without penalties assessed to your tenant. Or in the event of, for example, a mortgage, which isn't that frequent, the possibility of a cancellation or of a deferral or forbearance of your mortgage under the present terms. So that is what is being considered currently by a lot of realtors, a lot of sellers, a lot of buyers in these real estate transactions, particularly in purchase and sale transactions, because the whole goal may be frustrated by the fact that your buyer was a bartender, your buyer was a server in the restaurant industry, and right now they're out of a job and they don't have the ability to meet the requirements of their lender to comply with underwriting approval. And so there will be certain circumstances in which you could use force majeure to terminate a contract, and you just have to think about it on a case-by-case basis, whether the entire purpose of the contract has been frustrated. This also applies for a large commercial lease agreement, for example, or whether the act of God was unforeseen by all parties involved, meaning that they entered into the contract before or after it was declared a pandemic. That's huge. And also whether the local ordinances that have been put into place that have, for example, issued a shelter-in-place order make it just impossible to perform the contract for the foreseeable future, or whether it's just limiting it to the next 30 days or so, because that also will have an impact on whether that clause is feasible or not. So those are a few of the things that I wanted you to keep in mind when thinking about force majeure and the possibility of it affecting your real estate contracts. Good luck out there, investors.